Judgment in the appeal, McDonald versus Newton or McDonald.
Lord Hodge will explain the judgment of the court.
This appeal raises a question about financial provision on divorce in Scotland, in particular the extent to which a spouse can share in his or her spouse's pension rights. It is concerned with the interpretation of provisions in the Family Law Scotland Act 1985 and also regulations made under that Act. Mr. MacDonald was working as a minor when he married Mrs. MacDonald in March 1985. He had contributed to the British Coal Staff Superannuation Scheme since 1978. Unfortunately, he had to retire early on grounds of ill health in August 1985, not long after his marriage, and then received a pension under the scheme well before his normal retirement age. Mr. and Mrs. MacDonald's marriage broke down and they separated in 2010. In divorce proceedings, Mrs. MacDonald has applied for a pension sharing order, and a question has arisen as to the basis on which the court should make such an order, if at all. Her claim depends on Mr. MacDonald's pension rights being what the 1985 Act calls matrimonial property, which is the name given to property available to be shared on divorce. Section 10.5 of the 1985 Act, in Section 10.5 of the 1985 Act, the proportion of a person's pension rights, which may be matrimonial property, is the proportion of those rights which are referable to the period of the marriage until the final separation. The legal question concerns the meaning of that phrase and also the interpretation of a statutory formula in the regulations which gives effect to that provision. We are concerned in particular with the meaning of the phrase, and I quote, the period of membership of that party in the pension arrangement. Mr. MacDonald asserts that only such part of his pension rights as was attributable to the time when he was still employed as a minor and was contributing to the pension scheme falls within the definition of matrimonial property, while Mrs. MacDonald argues that the matrimonial property refers to the value of the pension rights attributable to the whole period of the marriage. If Mr. MacDonald is right, the rights which are matrimonial property have a value of about £10,000, while if Mrs. MacDonald is correct, the value of those rights is over 12 times greater. The sheriff supported Mr. MacDonald's view and held that the phrase, the period of membership of the pension arrangement, meant the period when he was employed and contributing to the pension scheme, and not the period once he was drawing his pension. A majority of the extra division of the inner house of the Court of Session agreed with the sheriff, but Lady Smith dissented. Mrs. MacDonald appeals to this court. In a unanimous decision, this court allows her appeal. The court finds that there are 4 reasons why the phrase is not confined to the period when the party was an active member of the scheme. In brief, first, the interpretation which the courts below favoured involved reading words into the regulations which were not there. Secondly, the regulations covered personal pension schemes as well as occupational pension schemes, and the interpretation which was advanced on Mr. MacDonald's behalf made no sense in relation to the former. Thirdly, his interpretation was not supported by the 1985 Act, which in Section 10.5 expressly provided for rights under a pension scheme to be treated differently from other assets. And finally, the court does not accept that the formula in the regulations was intended to require that membership meant active or contributing membership, because that would have been a very indirect way of doing so, and in any event would have apportioned the rights in a way which bore no relationship to the relative value of the rights acquired before and during the marriage. The court observes that it did not follow from the fact that the pension rights are matrimonial property that those rights will be shared equally. The court points to provisions in the 1985 Act which introduce flexibility into the award of financial provision to achieve a just result in the particular case.